So welcome and thank you for joining us for this breakfast briefing on data protection for pension schemes. My name is Lee Colgate. I'm a legal director in the pensions team at BDB Pitmans and I'll be chairing today's webinar. Now, few in the pensions industry will have escaped the flurry of activity on data protection matters that followed the introduction of the GDPR in May 2018, not least because pension scheme trustees, providers and many third-party advisors were responsible not only for complying with data protection laws, but also for demonstrating that compliance. So as we approach the 3-year anniversary of GDPR, and with the effect of Brexit on UK data protection obligations taking shape, now seems an appropriate moment for pension schemes to reflect on the effectiveness of their data protection processes and their ongoing compliance. I'm going to run you briefly through today's running order before handing you over to our speakers. In the first part of today's briefing, my colleagues Alexia Elassadi and Sarah Miller will guide us through the current data protection legal framework with a reminder of the key requirements. They'll look at data controller and data processor in the pensions context, the role of the ICO, discuss commonplace compliance issues, including data protection impact assessments and dealing with data subject access requests. And they'll touch on the main developments in data protection obligations since 2018. Alexia is an associate in the commercial team at BDB Pitmans with a focus on commercial contracts and intellectual property. And she regularly advises clients on data protection matters, including conducting GDPR compliance audits, as well as drafting privacy policies, data retention policies, and other key data protection documents. Sarah is a senior associate in the firm's pensions team and has experience of a wide range of pension advisory issues for occupational and personal pension schemes, but she has a particular interest in the application of the UK GDPR in pension matters. Once Alexia and Sarah are finished, we'll then hear from Matthew Searle. Matthew is the country director for Canon's consumer imaging business in the UK and Ireland and chair of trustees of the Canon Retirement Benefit Scheme for the UK. Matthew will share his experiences as a trustee dealing with subject access requests, and in particular how those subject access requests have become a useful tool for pension scheme members to get insight into trustee decision making and complaints handling. Matthew will also share his thoughts on what his trustee board might have done differently in some recent cases with the benefit of hindsight. Our final speaker will be Dennis Lee, who will discuss personal data breaches, including the obligations for data controllers where there is a personal data breach, and some recent experience of pension schemes handling such breaches. Dennis is a partner in the commercial team at BDB Pitmans and deals with all types of contentious and non-contentious commercial legal issues, including trademarks, brand protection, copyright, licensing, business contracts, and of course, data protection. So we have a lot of content to get through, and I hope it will be both interesting and useful. There will be time to answer questions at the end, and if you do have a question, I would ask you please to type it in the Q&A box, and we'll do our best to get through as many as possible. If you have any technical issues, then please let us know about those in the chat box, and we'll do what we can to help you out. So without any further ado, I'll hand you to Alexia and Sarah.
Thanks, Lee, for that introduction, and welcome everyone. If we can get the next slide up, please. And the slide after that, please. So you'll be hearing from me in different parts of today's presentation, but my focus in this first part is going to be on what I call the basics, namely the legal framework for data protection and the terms that we will be using throughout this presentation. Next slide. So here we've got the data protection framework in the UK today. You'll see from the slide that there are 3 main pieces of legislation. We've got the UK GDPR, which is the retained version of the previous GDPR. It is nearly identical to what we now refer to as the EU GDPR, apart from amendments that were made following Brexit. The government has published a Keeling schedule for the UK GDPR, which shows the amendments that have been made. We will just be referring to it as the GDPR for the purposes of this presentation. We've also got the Data Protection Act 2018, which was also amended slightly post-Brexit. And finally, we've got the Privacy and Electronic Communications Regulations, which are also known as PECR. These set out specific rules relating to electronic marketing and things like cookies and other similar technologies. Next slide, please. So who does the UK GDPR apply to? It applies to organizations that are established in the UK, but it also applies to organizations based outside of the UK, which either offer goods or services to UK data subjects or monitor the behavior of UK data subjects. Next slide. The Data Protection Act 2018 supplements the GDPR. There are some instances where you may need to refer to it, for example, when relying on certain lawful bases, as you may need to satisfy additional conditions and have additional policies and procedures in place. Next slide. Personal data. This is information that identifies a living individual, either directly or indirectly. An example of identifying someone directly is by reference to their name. However, you could also identify them indirectly by providing an opinion about them, commenting on their behavior, or describing certain characteristics about them. This is particularly relevant in the context of a subject access request, which we will touch on later on in the presentation. Personal data can be held electronically, which is self-explanatory, or in a searchable manual file. What does this mean? Well, the easiest way to think about this is by doing the temp test. If you had a temp in the office for the day, would they be able to extract information about someone without prior knowledge about them? The answer would be yes, for example, in relation to paper files that are organized alphabetically, but it would be no for a pile of papers on the floor. Again, this will be relevant in the context of a SAR when you're collecting the data, but we will touch on that later on. Next slide. Processing personal data. You'll see from this slide that really it's anything you can do with the data. It covers a broad range of activities. One of my clients asked a few weeks ago whether a third party would be processing personal data if our client shared their CRM system with them. The third party would not be using the data, but they'll be able to see it. And in that context, we still thought this constituted processing. So we needed to advise further on what measures our client had to take in relation to sharing the CRM system. I'll now hand over to Sarah, who will talk you through other key terminology.
Thanks, Alexia. So I'm going to discuss firstly the concept of controllers and processors. Controller is defined under the GDPR as a natural or legal person, public authority, agency, or other body which alone or jointly with others determines the purposes and the means of the processing of personal data. Most obligations under the UK GDPR fall on the controller. Trustees are the data controllers in relation to member personal data because it is the trustees who determine the purposes and means of the processing. It's possible that trustees may be joint data controllers with, for example, actuaries, or data controllers in common with, for example, the sponsoring employer. The ICO takes the view that professionals providing specialist services who are doing so in accordance with their own professional obligations will be acting as controllers. A processor, on the other hand, is a natural or legal person, public authority, agency, or other body which processes personal data on behalf of the controller. And under the UK GDPR, processors are subject to direct duties and can be fined for breaches and liable for damages. So it's not just controllers. Anyone who processes personal data on behalf of the trustees or a joint controller will be a processor, and these processors can then have their own subcontractors. The most obvious processors in respect of a pension scheme would be the scheme administrators, and that will include both third-party administrators, but also in-house administration functions provided by the employer group. There might be other advisors to the trustees who are also processors, for example, providers of consultancy services and auditors. Next slide, please. The ICO, the Information Commissioner's Office, is the UK's independent authority with responsibility for policing and enforcing the data protection and freedom of information regime in the UK. In addition to the legislative framework, the ICO has issued guidance on the UK GDPR to help organisations comply with their obligations. The ICO has a really large number of powers. examples of these are assessment notices, and that's the power to serve a written notice on trustees as controllers, requiring them to permit the ICO to carry out an assessment of whether the trustees have complied or are complying with legislation. Information notices, the power to serve a written notice on the trustees as controllers, requiring them to provide information that the ICO reasonably requires for the purposes of carrying out its functions. Then there's enforcement notices, which is the power to issue a written notice on the trustees, requiring them to take or refrain from taking the steps set out in the notice that where the ICO is satisfied that they have failed or are failing to comply with obligations. And penalty notices, the power to issue a written notice requiring the trustees to pay a fine if the ICO is satisfied that they have failed or are failing to do any of the things for which an enforcement notice can be issued, or have failed to comply with an information notice, an assessment notice, or an enforcement notice. So that gives you an idea of the extent of their powers. In October 2020, the ICO actually published draft statutory guidance for consultation, as it was required to do under the Data Protection Act 2018, and that sets out how the ICO would exercise its regulatory functions of information notices, enforcement notices, and penalty notices. While it's only still in draft form, the guidance provides some useful clarity as to the ICO's planned 9-step mechanism for calculating its fines. Next, oh, actually, sorry, I see we've already gone on to the data subject slide. So we've talked about processors, controllers, and the ICO, but who are the data subjects? Well, the data subject is the identified or identifiable living individual to whom the personal data relates. In relation to a pension scheme, as you would expect, the data subject will normally be the members of the scheme, but it might also be other beneficiaries, such as the children of members, spouses, dependents, etc. Under the UK GDPR, individuals have certain data subject rights over their personal data, including the right to obtain confirmation from the controller as to whether they process personal data relating to them. I'm now going to hand you back to Alexia, who's going to talk you through some key data protection principles.
Thanks, Sarah. The GDPR is a principles-based legislation. What do we mean by this? Well, there are 7 principles that must be complied with. In the interest of time, I'm going to aim to give you a general overview about these, but if you do have any questions, please pop them into the Q&A box. So the first principle is lawfulness, fairness, and transparency. Breaking that down, for processing of personal data to be lawful, you need to identify specific grounds for the processing. This is called a lawful basis for processing, and there are 6 options which depend on your purpose and relationship with the data subject. There are also specific additional conditions for processing some especially sensitive types of personal data, which we will address shortly. Processing of personal data must always be fair as well as lawful. In general, fairness means that you should only handle personal data in ways that the data subjects would reasonably expect, and not use it in ways that have unjustified adverse effects on them. Finally, transparent processing is about being clear, open, and honest with people from the start about who you are and how and why you will use their personal data. This is linked to the data subject's right to be informed. So the trustee's privacy policy would need to set out how they will be using members' personal data. The second principle is processing for specific and limited purposes. This means that if you collect data for a specific purpose, there are restrictions on whether you can then use it for another purpose. For example, you need to either obtain specific consent for the new purpose, or you can go ahead if the new purpose is compatible with the original purpose. Data minimization. Essentially, the data you collect must be adequate, which means it must be sufficient to properly fulfill your stated purpose. It must be relevant, so it must have a rational link to that purpose. And it must be limited to what is necessary, which means that you do not hold more data than you need for that purpose. The next is the accuracy principle. In practice, this means that you must take reasonable steps to ensure the accuracy of any personal data. You must ensure that the source and status of personal data is clear. You must carefully consider any challenges to the accuracy of the information, and you must consider whether it is necessary to periodically update this information. The next principle is the storage principle. This means that you must not keep personal data for longer than you need it. You must be able to think about and justify how long you keep personal data. You'll need a policy setting out standard retention periods wherever possible to comply with documentation requirements. You should also periodically review the data you hold and erase or anonymize it when you no longer need it. The next principle is data integrity and confidentiality. This means that you must ensure that you have appropriate security measures in place to protect the personal data you hold. Doing this requires you to consider things like risk analysis, organizational policies, and physical and technical measures. The final principle is the accountability principle, which sort of ties all the other principles together. To comply with this, you must have appropriate measures and records in place to be able to demonstrate your compliance with all the other principles. There are a number of things you can do. From the perspective of pensions trustees, these will include having a data protection policy, putting written contracts in place with your data processors, maintaining documentation of your processing activities, implementing appropriate security measures, recording and, where necessary, reporting personal data breaches, and carrying out data protection impact assessments for uses of personal data that are likely to result in high risk to individuals' interests. Hopefully this has given you a helpful overview of the principles. I'm now going to hand you back to Sarah, who's going to go into detail around special category data.
Thanks, Alexia. Next slide, please. In this next section of our talk, we'll be talking about some compliance concerns and developments. And as Alexia said, I'm going to start off with special category data. Next slide, please. As a refresher, you'll see from this slide what we mean by special category data. It's broadly data of a sensitive nature. Next slide, please. For any personal data to be processed fairly and lawfully, one or more of the bases for processing under Article 6 of the UK GDPR has to apply. These are set out on the slide, and you can see that one of them is consent. However, because of the practical difficulties in obtaining informed consent and the right of the data subject to withdraw it, whenever possible, trustees should always consider using one of the other 5 bases for lawful processing, each of which provides that processing has to be necessary for a specific purpose. However, for special categories of personal data, sensitive personal data, one of the requirements in Article 9 also has to be satisfied, and you can see the different bases set out for that in the slide as well. Next slide, please. The ICO has clarified in its November 2019 updated guidance that the legal claims basis for processing special category data in Article 9, which provides that where processing is necessary for the establishment, exercise, or defense of legal claims, or whenever courts are acting in their judicial capacity, is not restricted to current ongoing legal proceedings. And that was previously implied in its old guidance, and it can actually be relied upon where processing is necessary in order to establish, exercise, or defend legal rights in any way. And that's really helpful. So because trustees hold special category data in order to establish if a person has a right to a benefit, it's clear now from this updated guidance that they can use that legal basis and then avoid the practical difficulties of having to rely on explicit consent for special category data. Some of the difficulties of relying on consent include, for example, if there's no direct relationship with the individual, such as data concerning contingent beneficiaries, in death benefit nomination forms, or if the scheme already holds the special category data and there's no certainty that the beneficiaries would even respond to a request for consent. Our understanding is that the majority of schemes back in 2018 relied on consent for special category data, because at the time it was thought there wasn't really another feasible alternative. So this is a really, really welcome development, and trustees might want to consider taking advice on updating their privacy notices and policies so that they can communicate to members if they no longer want to rely on consent. Alexia and I are going to touch on DPIAs now, so I'll hand you back over to her. Thanks.
Thanks, Sarah. In summary, a data protection impact assessment, or DPIA, is a process to help you identify and minimize the data protection risks of a project. You must do a DPIA for processing that is likely to result in a high risk to individuals. To assess the level of risk, you must consider both the likelihood and the severity of any impact on individuals. A high risk could result from either a high probability of some harm to the individuals or a lower possibility of serious harm. Over to you, Sarah.
Recent ICO guidance has clarified some examples of what would be high risk, which are quite likely to be relevant to pensions trustees. One would be invisible processing that relates to vulnerable persons. And the other would be decisions about an individual's access to a benefit, which involves processing special category data. However, the ICO indicates that a DPIA may not be needed for existing processing where a controller has already considered and assessed the level of risk. So it's possible that an informal risk assessment back in 2018, for example, any special measures put in place for processing, consideration of how the data is held, legal advice received back then, and the work carried out on supplier contracts, records of trustee discussions and things like that might suffice. Trustees may want to take legal advice on whether an informal risk assessment could be concluded to have taken place in 2018, or reconsider again if a DPIA might be needed, and update their data protection policy accordingly. I'll pass you back to Alexia now. Thanks.
Thanks, Sarah. So in this next slide, we're going to talk about international transfers. We've set out here broadly the three categories of transfers that we'll be talking through. The first of these is transfers of personal data from the UK to the EEA. The good news here is that there are no changes to this type of transfer, as the UK has deemed the EEA to be an adequate jurisdiction for data protection purposes. In respect of transfers of data from the EEA into the UK, there was a concern about this post-Brexit, about whether data would be able to flow from the EEA. The good news is an adequacy decision in favor of the UK is imminent. And in the meantime, there is a bridging mechanism under the Brexit trade deal, which allows personal data to flow in this direction. As for non-EEA transfers, trustees can transfer personal data to non-EEA third parties in jurisdictions where the UK has given an adequacy finding. In the absence of an adequacy decision, the trustees would need to see if a safeguard would be appropriate, such as standard contractual clauses or binding corporate rules. Trustees may wish to check to ensure that appropriate safeguards are in place and that appropriate assessments have been carried out. The ICO has recently released its guidance for organizations who were relying on EU binding corporate rules as an appropriate safeguard for international transfers from the EEA. Finally, in the absence of an adequacy decision or a safeguard, you would need to check if one of the derogations under the GDPR will apply to the transfer. Next slide, please. We spoke about data processors earlier, and now Sarah and I are going to go into a bit more detail. So if you've appointed a data processor, you must enter into a written agreement with them. This agreement will need to set out the nature, purpose, and duration of the processing, the type of personal data being processed, and the categories of data subjects whose data is being processed. There are also a number of obligations that are imposed on the data processor, as you can see from this slide. I'll now hand you over to Sarah to talk through some of the specific consideration from trustees' point of view.
Ahead of the introduction of the GDPR, trustees would have had to have reviewed and updated all of their contracts with entities processing personal data in relation to the scheme's members. I'm sure we all remember that in 2018 very vividly, overhauling all of those contracts. And the reason for this is that the UK GDPR, the GDPR sets out a really prescriptive list in Article 28 of what those contracts have to contain. Compliance with these requirements is something which should be watched out for in all contracts with processors. It's very, very easy to fall foul of the necessary requirements because the clauses are so prescriptive. The most notable example of a processor contract which should contain the Article 28 clauses would be the administrator contract, but they're required to be in all processor contracts. Next slide, please. Alexia's already touched on data retention and deletion, but I just wanted to mention it briefly as well. Trustees must provide beneficiaries with information about the period for which data will be stored. And if that's not available, the criteria used to determine that period has to be provided. The stated criteria could be that trustees must retain the data for as long as is necessary to fulfill the legal obligations owed to the beneficiary. For example, the duration of the trust period, so it can be a really long time, for the duration of the administration of the trust, or for the limitation period for bringing legal claims for breach of trust. So there are a number of options. I'm going to hand you back to Alexia now to discuss subject access requests.
Thanks, Sarah. So I'm going to give you an overview of subject access requests and some of the basics to keep in mind when you receive one. And then Sarah will take over to talk about trustee-specific considerations. So what are subject access requests? The right of access, which is commonly referred to as a subject access, gives individuals the right to obtain a copy of their personal data, as well as other supplementary information. In terms of the timescales for responding to a SAR, the default is you must respond without undue delay and at the latest within 1 calendar month. Time starts to run from the date you receive the request or any additional information. For example, if you've requested ID documents, even if that day is on a weekend or a public holiday. In terms of the deadline, this would be 1 calendar month from that date, unless the end date falls on a weekend or a public holiday, in which case it ends on the next working day. If the corresponding calendar date doesn't exist because the next month has fewer days, then it would just be the last day of the month. The deadline to respond can be extended by up to 2 additional months if the request is complex or if there are numerous requests. But it's worth mentioning that relying on a data processor does not make a request complex, neither does being short-staffed. So if you do have a particular reason for requiring an extension, you must inform the data subject of this within a month, explaining the reasons for the extension and letting them know that they have a right to complain to the ICO. There are limited circumstances when you may not need to respond to a SAR, and this is where a request is manifestly unfounded or excessive. What do we mean by this? You shouldn't have a blanket policy for determining whether a request is manifestly unfounded or excessive, so you must consider each request on a case-by-case basis. A request is manifestly unfounded if the individual has no clear intention to access the information, or they are malicious in their intent, and they're using the request, for example, to harass the organization with no real purpose other than to cause disruption. A request can be excessive if it repeats the substance of previous requests, and a reasonable interval has not elapsed, or if it overlaps with other requests. In most cases, a request will not be excessive just because the individual has asked for a large amount of information, even if you might find it a burden to respond to. Remember, in this case, you could ask them for clarification or for more information to help you locate the data that they want to receive. If you do refuse to comply with a request on one of the grounds I just mentioned, then you must inform the individual about the reasons why you're not complying with the request, and again, inform them of their right to make a complaint to the ICO or another supervisory authority as applicable, and their ability to seek to enforce this right through a judicial remedy. Sarah, over to you.
Thanks, Alexia. There are some practical steps that trustees can take to minimise how much information will need to be disclosed in response to a DSAR. Firstly, the UK GDPR provides that a right to obtain personal data shall not adversely affect the rights and freedoms of others. So redacting text which relates to other members or the trustees themselves could be a useful tool in the event of trustees exercising, for example, their discretion to pay out death benefits. A Hansard transcript from the House of Lords stated that rights and freedoms of others includes the rights of both trustees and other beneficiaries, where disclosure under data protection law would reveal information about a trustee's deliberations or reasons for their decisions that would otherwise be protected from disclosure under trust law. The government's view is that disclosure would adversely affect the rights and freedoms of trustees and beneficiaries in the trustee's ability to make independent decisions in the best interests of the trust without fear of disagreement with beneficiaries. So that indicates that trustees may still rely on the principle that a beneficiary does not have an entitlement as a right to the disclosure of trust documents to withhold information from a DSAR which relates to the exercise of a discretion. Trustees should therefore consider if a court would deem in its discretion that the documents should be disclosed. The answer to that will, of course, depend on the circumstances and balancing the interests of the beneficiary, the trustees, and third parties. Another avenue which could provide assistance with a DSAR is legal privilege. The right to make a subject access request does not apply to personal data where it consists of information in respect of which a claim to legal professional privilege could be maintained in legal proceedings, or information in respect of which a duty of confidentiality is owed by a professional legal advisor to a client of the advisor. So that's really useful because it's actually wider than legal privilege. Another way which might provide assistance would be avoiding using member personal data at all in communications, minutes, advice, wherever possible. That can be made easier by avoiding using email chains, referring to the member in an anonymized manner, not including any identifiers for the member, such as date of birth or descriptions that could reveal who they are. Personal data that has been anonymized is not subject to the UK GDPR, but in order for it to be truly anonymized, you must strip the personal data of sufficient elements that mean that the individual can no longer be identified for that to be useful. I'm going to hand you over now to Matthew Searle, a lay trustee, who's going to talk a little bit about his recent experience with a data subject access request. Over to you, Matthew.
Okay, thank you very much. Thanks, Sarah. Thanks, Alexia. Yeah, if only I'd known what I know now when we had our first subject access requests, and when the team at Pitmans asked me to talk today, I came out in a bit of a cold sweat, really, because it brought back two painful experiences for us of the situation when we had subject access requests as trustees. So today I'm going to share a couple of examples of how we found out the hard way how challenging, time-consuming and difficult to respond to subject access requests can be, and also plus what we do differently with the benefit of hindsight. So the first case we had was a contested death benefits case. And from the very beginning, we had many people corresponding with the trustees, with the company, with the administrators. So there was a lot of personal information coming in from many sources into very different parts of the business. And much of this information was shared amongst trustees by email and by hard copy, because it was relevant to our decision-making process. And one member, or one individual in particular, made multiple complaints under the IDRP, and they subsequently turned into multiple complaints to the Pensions Ombudsman. And in this case, the subject access request came in quite late in the process, probably 18 months into the process. By this time, there'd been a hell of a lot of data built up. And it was very early in the life of subject access requests, so no one really knew what the correct way to respond to them was. And there was a massive effort on our part, collating, sourcing, reviewing information. I remember in the days when we could go to London, going up on a train with a rucksack full of documents, which we sat for 5 or 6 hours with Pitmans going through, redacting and considering what we should and shouldn't disclose to this member for the SAR. We did the SAR response. The member immediately referred that to the Information Commissioner's Officer, complained to them regarding the redactions which we'd made to protect other members' data and our privacy. The ICO investigated, we responded to the ICO, and in that case, the ICO wanted some examples of some of the data we redacted, which was quite interesting. And ultimately, the ICO backed us in that case. The individual concerned kept corresponding and building up more data, sending in more information to us. They then sent a second SAR in to test us. We responded to that one in full as well, albeit we didn't share the data we'd shared previously. And then probably 4 weeks later, they put another SAR in. This time we rejected that on the basis that it was excessive. The member again referred us to the ICO, but luckily the ICO backed us again on that one and decided that we were right in terms of being able to reject it on the basis of being excessive. The member even put a SAR in for the deceased, or the individual, or even put a SAR in respect to the deceased member, which we declined. But it shows how people use SARs quite relentlessly to try and get information out of trustees. So yeah, that was a very difficult case. The second case we had where a SAR came in, pretty similar timing actually, was a complaint over transfer value where the trustees had applied an insufficiency measure. This would eventually involve claims management companies and the press. And a SAR, again, was a fairly key part of the tools they used to try and get the trustees, or to force the trustees into a particular course of action. Again, it's clear to me that subject access requests are increasingly being used as a key tool for complainants, both from a phishing perspective to try and find information, and also as an attrition mechanism to try and wear trustees down. Even if you're on solid ground and have made the right decision, it's just using it to try and wear you down to the point that you make an agreement with an individual in their case. Again, this one was multiple correspondence over a very long period, initially friendly and constructive, but over time it got more demanding and more aggressive, the correspondence between the member and the trustees and our advisors. Frequently we'd get 8 pages of documentation with questions, demands, observations, often very personal about the trustees and the advisors, and normally on a Friday afternoon at 4:30, just really designed to make our weekend. And it's a very scattergun approach. This person would send emails to various people in the organisation, knowing that they'd then refer it to trustees and knowing that that might elicit a response from the trustees. So the HR director, the managing director, former colleagues. And again, the SAR came in quite late in the process after a lot of correspondence and a lot of internal discussion by the trustees. And in this case, the SARs were very specific, detailed, very knowledgeable, covering all the bases with very specific information, obviously designed to try and elicit information on our decision-making process and to find holes in our decision-making process, and designed to put the trustees on the back foot. Again, we took advice about sharing, about what we should reply to, but we responded to it very openly and pretty much in this case disclosed most information without redaction. It was quite an emotional case, and unfortunately, one of the things we learned from it is, in hindsight, we had to disclose some information that we wouldn't want to have become in the public domain. When you do get emails from people on a Friday afternoon at 4:30 being very personal, especially if you had a bad week, sometimes you respond with an "oh no, not again" email, or I sent one email, not even about this individual, but just about angry people. And that information got to that individual in the SAR, and that was then used. We then had the press coming to us, using those quotes and using that information to try and suggest that we weren't fulfilling our duties properly or doing our job properly, and that we'd been biased against the member from the start. So very well utilised and crafted to try and make us change what was a legitimate decision. In that case, we held our ground. We bared our teeth a little bit because some of the things they were doing were borderline threatening. But the member went away. But it was a good example again of how the subject access request was used to try and question the trustees' decision-making process and to try and put the trustees on the back foot. And more than anything, as an attritional tool to try and wear us down into making a settlement with a member in a case where we did no reason to make a settlement. So what did we learn from those two cases? Well, number one, not so much about SARS, but we're a very approachable, engaged trustee board, and we do talk to our members quite a lot, especially when you're an employer or employee still of the organisation, and many of these people are your colleagues and former colleagues. But this can cause issues. So the advice really is to limit the amount of engagement and correspondence you have personally with members. Leave it where possible to your scheme secretary and administrators. I think our biggest learning point, as was alluded to by Sarah and Alexia, is anonymise, anonymise, anonymise. You don't realise how quickly personal data builds and spreads. And if you have a case where you think it could become contentious, quite quickly move to anonymising the data and having no personal data, as in the names primarily, in your internal dialogue and in internal discussions about it. If you remove the name, you remove many of the potential issues from a subject access request perspective. And since then, we've changed a lot of our processes anyway to delegate some of our, especially around death cases, delegate some of our more standard discretions and reduce the amount of correspondence and amount of data moving around the business. Don't hold personal data, correspondence for longer than is required. Delete, return, dispose. Legally, of course, taking the advice of your lawyers and following the policies, but don't hold on to a mass of personal data for any longer than is necessary. And finally, on that point, take advice. If you do get a subject access request, take advice on what you can and can't withhold or redact. You have a duty to protect others as well as fulfilling your obligations to the individual who's made the subject access request. And you have the right as trustees, which we didn't know so much then because the case law and the rules hadn't really been set, but you have quite strong rights in terms of protecting your privacy around your decision making. So final thoughts, I think subject access requests are here to stay. Increasingly, they're going to be used as a tool in complaints, either as a phishing exercise or a nuisance, and be standard, often without merit, sometimes with merit, but often without merit. And a more generic thing, not related to standard subject access requests, is if you are having this dialogue, don't put anything in an email you wouldn't be happy finding shared ultimately in the public domain. But yeah, subject access requests, I think, will increasingly be something that we as trustees have to deal with. But there are things you can do in advance to mitigate the impact of those and reduce the impact on your business, because it can be time consuming and painful when you get one. And that's our experience. And I say, hopefully today you'll learn a few hints and tips which will maybe stop you falling into some of the traps we did as trustees. And on that point, I would like to hand over to Dennis, who's going to take you through the next section. Thanks, Dennis.
Thank you, Matthew. Thank you so much. It's really, really useful to hear from the trustee's perspective. Obviously, we're always looking from our angle as an advisor. So thank you very much for sharing that. Now, I'm moving on to data breaches, and there is a reason why we leave these two topics, the SARS and data breaches, right at the end of this seminar. It's because they are the most likely to be the serious incidents that you as trustees will encounter. And even though data breaches are less common than SARS, As Matthew correctly stated, SARs are increasingly used these days, but data breaches are nonetheless potentially very serious. So under the UK GDPR, all organizations, obviously including pensions trustees, must report certain types of breaches to the ICO within 72 hours of becoming aware of the breach. Now, 72 hours from our experience is often very, very short. In many cases, by the time they come to us, the breach is informed to the lawyers. It's often very late, or sometimes even out of those 72 hours. Now, organizations are not required to report the breach if they are unlikely to result in a risk to the rights and freedoms of natural persons. Now, this is obviously difficult because you need to assess this. And very often this is also what our clients come to us about, how to assess whether or not there is a need to report. And later on, I will give you some examples of where it's unclear whether you should or you shouldn't be reporting. So the concept here is high risk. You have to consider whether a breach is likely to be high risk, and you have to take into account the impact and any negative consequences to the individuals whose data is involved. If the breach is likely to be high risk, then the individuals themselves must be informed. So can you imagine if that is your assessment and you have thousands of individuals whom you must inform? It is actually a big task. And obviously in doubt, it's better to report. And that's I will give you some examples as well of how we have dealt with these where it is uncertain and it is always results in a better result if you report it. So how we can assist, it's unless you are very confident and have dealt with some data breaches in the past successfully, then we would advise that it should be consulted to lawyers, because it is potentially a very, that there are very high fines that the ICO could impose. And how we assist is we obviously need to know as much as we can, and in order to assess it, and then we will advise on how you go through the reporting process. There are certain fixed requirements of how you report, but then after that, there are also processes where the ICO will write back to you. They may have further inquiries, and then we can advise the trustees how to respond to those. So generally, even if there are no breaches, even if you have never experienced any breach and everything is ticking along nicely, the organization must still have breach detection, investigation, and reporting procedures in place. So this is regardless of the fact that whether you think you are likely to encounter any breach. And even if if they do occur, and you decide that it's not necessary to report to the ICO, you still need to document the breach, and you need to have a data breach log, basically, and also write down the facts surrounding the breach, the effects of the breach, and the remedial action, if any, were taken by the organization. All these needs to be documented. This is in case something does happen and the ICO then comes over to investigate. Now, appropriate technical and organizational measures may include, as quite similar to what Matthew was mentioning, pseudonymization and encryption of personal data, the ability to ensure ongoing confidentiality, integrity, availability, and resilience of processing systems and services, and the ability to restore the availability and access to personal data in a timely manner in the event of an incident, and regular testing or evaluation of the processes of these measures. Now, why is this so important? It's because the maximum fines that the GDPR allows for the ICO to impose is £17.5 million, or in the case of a breaching party that's not a company, 4% of the total worldwide annual turnover, whichever is higher. So as you can see, as trustees, this is not something that you should take lightly. There are some examples in the media of there are many examples of data breaches, obviously, but there are some relating to pensions. And in fact, just late last year, end of last year, in fact, Now Pensions, one of the largest pension providers, suffered a data breach when one of its service partners unintentionally posted members' personal data on a public software forum. Now, we don't know the full details of this case because it hasn't been fully reported yet, and we don't know what they will be fined either. So we should watch this space to see what was the fine, especially, and that would give us some indication of what other similar breaches would result in. However, I thought it would be also useful to go through two cases, less serious, but quite interesting, to let you know how you might actually encounter. And these are actually cases that we've been involved in, where the trustees of a particular trust were advised by their administrators that a potential cyber incident occurred on their actuaries system, which may involve some scheme data. And unfortunately, they decided not to take any action. And only after several months, they came to ask us whether they should have taken any action. And even though after assessing it and going through all the details, it was decided that it was not sufficiently serious to report to the ICO, they nonetheless should have actually documented the whole process, which they didn't. And therefore, our advice was to go through that, the full step of documenting and recording the incident under a data breach log, and also carefully minuting what has happened and what the effects are and why the decision was taken not to report to the ICO. So nothing did happen in that case. Another one, also very interesting, is a trust where a former trustee actually, who's left the trust 10 years ago, turned out to have retained a large amount of scheme data on a personal computer. So obviously that, I'm sure it already rings alarm bells to many people, because once a trustee is no longer a trustee, that data should have been returned or destroyed. That wasn't the case. And it was found out actually a long time after the trustee left. And we advised that there were potentially two breaches. The first one was the non-return and destruction of the data, because that data belongs to the trust, and it is held in that former trustee's computer. So that should have been done. And the second one was that the transfer of the data to the trustee wasn't done securely. So there was no very safe way of doing it. And this could have been a data breach as well. We advised that it would be better to notify the ICO, which the trust did, but nothing came out of that. The ICO didn't make any further inquiries. So it was also a happy ending in that particular case, but obviously not always that, it always ends that well. There are many cases reported. Also, you can easily find some reported cases on the ICO website, some about other pensions trusts as well. Many of them also relating to making unsolicited marketing calls, which we don't need to go through. But these are also data breaches. And also there are many non-pension trustees data breaches that are very high profile, such as the recent fines that were imposed on BA, Facebook, and Marriott Hotel. These are all in the news, actually. Then on that point, I think I would pass back to Lee to wrap up. And there is, I think I've covered all my points here.
Thank you, Dennis, and thank you to all of our speakers today for some really interesting and useful insights. For me, I think there are a few key takeaways. One, that it's important to consider data protection at an early stage of any pension scheme process, and in particular to recognise that trustees will have to think carefully about the risk that internal discussions and mechanics of decision making could become available to individual pension scheme members unless personal data is carefully managed. It marks a new challenge for trustees of occupational pension schemes in particular, and trustees should think carefully about the processes that they have in place to manage that risk. Two, robust policies and procedures are essential to demonstrate compliance, but more importantly, they'll help the parties to understand their roles and their responsibilities and to take action in the appropriate manner and in the timescale imposed by the UK GDPR, and of course, to help minimise risk. As such, policies and procedures should not just be filed away and forgotten. They're live documents that should be kept under review, and pension scheme trustees should consider keeping data protection issues and processes on their meetings, on their agendas for meetings going forwards. And finally, it strikes me as always from a pension scheme perspective that this really is about managing risk. And given that pension schemes rely heavily on third-party service providers, ensuring the agreements with those third-party service providers clearly set out the allocation of responsibility and liability is key. And trustees may also wish to consider the availability of appropriate insurance in respect to these matters. I think we have a couple of questions in. We've got a few minutes left, so I'll try to get through those. The first is, can the panel, excuse me, can the panel give any practical tips to trustees who want to anonymise personal data? Does using initials, for example, go far enough? Perhaps a related question, is just the name John Smith or Jill Brown identifiable on its own? Surely there's so many people with this name that a breach would have to involve more than just a name like this to identify an individual. So I think they're probably connected questions.
Yeah, I'd be happy to take those questions, Lee. So those are really good questions. The first part about anonymization actually coincides with the ICO's recent announcement that it will be issuing guidance specifically dealing with anonymization and pseudonymization. Just to reiterate the difference between the two, so anonymization is the process of changing data so that it is no longer personal data. So it doesn't identify a living individual. Once the data is truly anonymized, it will no longer fall within the remit of the GDPR. By contrast, pseudonymization is a technique that replaces or removes information in a data set that identifies an individual. So this can involve replacing names or other identifiers with, for instance, a reference number. You can tie that reference number back to the individual if you have access to the relevant information. So essentially, pseudonymization is a security measure, so you're still dealing with personal data. Going back to the question, if trustees, for example, or the administrators of the scheme or the actuaries are looking to anonymize data, they must exercise caution. Because we've seen examples where organizations have referred to data being anonymized when actually it hasn't been. So they would need to ensure that any treatments or approaches they take truly anonymize data, because if, for example, the use of initials might not suffice, you might still be able to identify the individual from their initials. And the danger there is if the data is not truly anonymized, then it's pseudonymized and it's still processing of personal data, and you still need to comply with the GDPR. On the question about breach, I think there are slightly two issues there. So when you're looking at a name, someone's name is their personal data. When you're faced with a breach, the assessment really is, do we need to report to the ICO, and do we need to report to the individual affected by the breach? So John Smith or whatever the name is. And that's going through the assessment that Dennis mentioned. So thinking about the risk and the harm to the individuals. So if the breach is to a degree that's going to impact them in a negative way, then the individuals will need to be informed. So I hope that's addressed those two questions.
Thanks, Alexia. Another question I think is, does the panel have any views on how data protection legislation will interact with the requirements coming in to provide information to a pensions dashboard?
I can take that one, Lee. My understanding of the dashboard requirements under the Pension Schemes Act is that they wouldn't authorise or actually require processing of personal data to the extent that it would breach data protection legislation. It seems to sort of indicated that there might be some express exceptions in regulations to the data protection requirements, but also I don't think that regulations would be read as authorizing or requiring the processing of data if it would actually be a breach. There's an indication that processing personal data might be lawful under regulations because it's required for compliance with a legal obligation. So that's an area that we can keep an eye on while we're waiting for the draft regulations.
Great, thanks, Sarah. And just to thank you all very much for attending again, and to wish you well for the rest of your day. Thanks again.